Good afternoon, evening. I'm only late because I got stuck in an elevator. I literally got stuck in an elevator. Hope everybody's well. It is Friday afternoon Pacific time, 3:31. So this week, what I'm going to do, because I always tell you what I'm going to do, I'm going to tell you about the proceedings that happened in court this week. I'm also going to tell you what I did and what I'm going to do, following up on what we said before. And I think that's about it. I'll try to keep it short and sweet, although that's impossible, unfortunately. But I will try my best. Before I start, of course, I wanted to see what I could, again, going to Claude. This is Claude is Anthropic's model, learning's LLM. I won't say it out loud. And what I tried to do this week, just try a different little take. I tried to have Claude make fun of me. That was the idea. But it came back that I can't write jokes mocking a specific real identifiable person by name. That applies whether it's a public figure or a YouTube creator. So it wouldn't do that, but what I tried to do is make it kind of generically apply to me, kind of using other ways of kind of cluing them in. And so I asked for 7 jokes, and here they are, about a fictional lawyer turned YouTube legal commentator. That's kind of the description. 1, he passed the bar, but his real specialty is passing judgment from a home studio with better lighting than his actual office. 2, he's billed exactly 1 client this year, his sponsor, a mattress company that supports every objection. That was a pun there. 3, his legal analysis is airtight, except for the part where he never actually filed anything in the case he's narrating. An exception, in the case that I'm following, I actually am filing things in there. Interesting. I guess it didn't pick that up. 4, he calls it breaking down the filing. Everyone else calls it reading the docket out loud with dramatic music. 5, he got a law degree, a ring light, and a strong belief that, quotation marks, anal, close quotation marks, doesn't apply to him, even when it probably does. 6, his retainer agreement has fewer words than the average video description. If you saw my video descriptions, it's a funny statement. And last but not least, he's technically licensed to practice law in 1 state and unlicensed to practice restraint in all 50, which I'm sure the receiver and the Receivers Council probably would say in this particular matter. So thank you, Claude, for these wonderful jokes. Claude is one of my most loyal followers. He's always here. He always supports me. So thank you, Claude. So let me kind of go through what we're going to do. So what I'm going to do is I'm going to go in backwards sequence. I'm going to keep what I'm going to do in my interactions to the end, and I'll do that at the end. And what I'll do is I'll talk about the hearing on the 13th. So there was a hearing on the 13th. You said there was a hearing on the 13th? Yes, there was a hearing on the 13th. The second hearing? I guess this would be the second hearing before Judge Hardy. Yeah, second hearing before Judge Hardy. This particular hearing, again, Judge Hardy is very new to the case, so is just developing an understanding about the case, which is fair. I think it's very fair that he's developing an understanding. And there were 2 matters before. Well, actually, there was 1 matter before the court, and there was another matter that was kind of sort of before the court. And I'll explain. The first matter before the court was the settlement agreement that they entered into with Frank Benintendo, where in essence he was going to turn back all his shares and they were going to let him go. I filed an opposition, not that I really objected to that settlement so much as I objected to the settlement be done without the audit being completed. I communicated that to the judge. I wasn't not surprised that the judge granted the motion, nor am I was concerned about that, but I certainly wanted to express my concerns about the lack of audit so that if the receiver, for example, the receiver's counsel comes back trying to do a settlement with Reichman, then maybe the discussion's different if the audit's not done. And one of the distinctions was, and I think I'm just going to say it out loud so I can cite to this some future point in time. The counsel for the receiver was clear on kind of indicating that, obviously that the Benintendo was responsible, but that he was negligent, not that he was doing anything intentionally wrong. And so that's fine. And I don't have any objection or disagreement with that. However, when the time comes, if there's discussion and papers filed in court trying to justify a settlement with Reichman, either of the Reichmans, that won't be available. The fact that it was unintentional, they were just neglectful, because again, the receiver has spent 7 reports plus a summary report describing all the misconduct of everybody named Reichman. And I'm kidding there, but obviously the main players in this case. So if they did it intentionally, then the statement in here that they were only negligent, I think, can be used against any kind of those settlements if we have any cause to object to that. And again, I've stated my position with regard to Reichman settlements. I think that as to the principal Reichman, the actual one, and I know the receiver's counsel doesn't like when I say this, but this is just my position, my feeling, that I don't think there should be any resolution with Reichman. I think he should return all his shares and suffer the consequences of his actions without getting any break, any settlement discount, nothing. That's my position. And I understand, like, from a monetary point of view, that's difficult, especially when the receiver says there's less than $10,000 left in the coffers. But be that as it may, that's why I opposed the settlement. Judge said go forward. Separate and apart from that, the receiver at some point in time can issue, and again, I don't know if Nevada is the same way, but something called like a receiver certificate. If the receiver wants to borrow money, in essence, he can issue something called a receiver certificate, which is kind of the same as maybe a promissory note that exists, and those notes have a priority over everything else. So the receiver can use that to borrow money if the person who's lending the money believes they will get paid back and they would get some priority. So I don't know if that's what's going to happen. In recent conversations, when there was a discussion about funding, at least the start of an audit, I heard some discussion about that. So we'll see what happens about that. That's complete non sequitur to what I was talking about, but I didn't want to forget to state that. So we have the Benintendo settlement. Judge said okay, and again, I'm not going to make a federal case out of it. It was more the point about the audit, because I'm establishing that as an issue. So if we are in a position down the road where the audit still isn't done, I will raise it again. But that's where we are. The second issue, or second motion that was pending, or it wasn't pending, I think I had indicated before, and it was public, that there was a motion to intervene that was filed by a Trento group, and that motion was withdrawn, I think a day before or 2 days before the hearing. The Receivers Council filed a opposition and a request for fees, because their position was, and again, this is my interpretation of what their position was and my opinion only, but their interpretation was, if you would, we spent a bunch of time on it, and if you had not filed a motion, we wouldn't have spent the time. And also, apparently, there was a request that the motion be heard kind of on an advanced notice, short notice. So with that, they argued that there should be even though the motion itself was not going to be considered by the court and wasn't on that day to intervene, they asked that fees be provided as opposed to sanctions. There's a distinction between like sanctions for misconduct or something like that versus fees that would be reasonable. So the judge indicated that he was going to award fees, told the parties to get together to kind of figure out a number. If they couldn't figure out a number, then the judge would. It's not going to be a huge sum of money, but that was the conclusion of the intervention. There was no ruling on the actual intervention. I think for the intervention to be considered, there has to be additional documentation that's provided. I don't know what the specific intention is, when, where, whatever, but that's how it ended. So there was no actual ruling on the intervention at that hearing. There was a ruling on the attorney's fees request, and that's pending. So those are the two items that were heard on the 13th. Now, at the end of the hearing, there was nothing currently scheduled on the court docket, so I made sure. And who was there? Attorney for the receiver was there. The receiver was on Zoom. I was on Zoom. The attorney for Trento was there. A couple of representatives for Trento were there. I think that was it. Hearing, the judge made his rulings. I indicated there was nothing on calendar. I requested that we have a status conference set for the next available date so that we can keep track of what's going on in light of the problems with the audit, et cetera. The court agreed or entertained my request and set it for October 6th, which is our next status conference. So that's currently the next court appearance. Could there be a court appearance before that? It's very possible, but that's kind of where we are up to date as to that. So now I'm going to move to a separate thing. So kind of what we've talked about, you and I talked about, maybe probably the last live stream. I said that I brought up a bunch of issues and, I'll summarize it better. So we were in court last time and I indicated it was a first status conference. I made my points, my 5 points about various issues. The court heard it. I also suggested that I was going to, or at least was contemplating making a motion either to terminate the receivership or modify the receivership or something to do with the receivership. The judge said, that's fine, but could you meet and confer with opposing counsel to discuss whatever your issues are? I said, fine. About a day after, no, the same day of that hearing, which is about 2 weeks ago or so, I was contacted by one of the attorneys for the receiver. I wasn't available. The next morning, I contacted him. We had a very pleasant conversation. He indicated I would be contacted, or a further meet and confer, as it's called, would be available the beginning of next week. I reached out to other counsel. We set up a meet and confer for Monday with the receiver's counsel. A very amicable interchange in that particular discussion. And in that discussion, so this was the discussion the judge requested before I file any kind of motion to do with terminating the receiver or the receivership. And it was with one of the attorneys for the receivership. Again, both attorneys, especially the last couple of interactions, have been very cordial, although can't say that's always been the case, but it's been. So I have no real complaints about those gentlemen. And it's, and obviously they're doing their job. Most of my complaints, issues, almost all of them have to do with the receiver, not against anybody else, or decisions that the receivers made. And, and again, that stuff may not be intentional. That may just be a lack of experience, lack of competency. I don't know. And again, that's just my opinion. And it relates just to certain issues, not everything. But kind of that's where it is. So on Monday, the August 10th. Today's the 14th. I had a telephone conference with one of the attorneys for the receivership. We talked about the loan investment. We talked about cash settlement. We talked about marshaling the audits, the assets. We talked about the audit, and we talked about the status of outside transactions. And I'll kind of go one by one, because what I did is afterwards, I kind of sent out an email kind of describing what was discussed. And that was sent out Monday, also the 10th of August. And today is the 14th, and I haven't heard anything to the contrary. So if I believe that if there was something substantially wrong in my recap of the details of our discussion, that it would have been pointed out, but it wasn't pointed out. So I'll just kind of go through it. And then I'll get to the conclusion. There is a conclusion here. So the loan, whatever, I pointed out that, again, the problem was the discrepancy between being called a loan and being called an investment. The attorney indicated that he believed that they were the same transaction. So even though it appears they're being called something differently, and maybe they were filed in SEC filings, and again, that's my take on it, they appear to be the same filing. I also indicated that, and I indicated in the email, that the problem I really saw was that it was to a friendly, and that there was no disclosure, and that the fact it seems to be inconsistent filings. I didn't get a response back really from the attorneys. They just kind of listened. They didn't say I was wrong. They didn't provide like a contrary view. They didn't pick into any particular fact that I recall. So I kind of left that as, and I think the attorney wasn't specifically aware of where it was referred to in a prior report, but it didn't seem like they really disagreed with my conclusion. Now, they may disagree with my interpretation, but since, again, they haven't responded and a few days have passed, and so my opinion is that that's still problematic. And the fact that we have a transaction referred to as a loan with a return on investment, and same time being also investment. So, excuse me. It's characterized as an investment with a return, like of 6% in 1 week, and then it's characterized as a loan. It can't be both. So it's confusing. And the fact that there were apparently filings with the SEC that may have characterized the same transaction differently, I think could be very problematic. And I didn't hear anything from the Receivers Council to convince me otherwise, nor have I received anything since to convince me otherwise. I think it creates an issue as to, since there was no court approval of the transaction, I think it just raised a lot of issues. Lack of transparency is the least of the issues. Why is the bankruptcy estate loaning money? Why did it lose money? Why are these transactions referred to differently when they're the same thing? What about the return? What about the filings with the SEC? Does that create other issues? I think it does, by the way, but I don't know. So didn't get any real feedback contrary to that. Cash settlement, that's issue number one. So issue number one is with regard to the loan versus the investment at $100,000. It's still a problem in my mind. Two, cash settlement, I bitched about the fact that it wasn't disclosed that the receiver had a prior business relationship with one of the parties they indicated they were going to settle with. My recollection is the attorney for the receiver agreed that should be disclosed, that relationship. But as of today, I haven't seen that. Three, marshaling assets. That's where I indicated that the receiver had brought in all kinds of money. However, we have no idea how it was spent. So I said, I'm sure that you've spent a lot of money and it's probably on good things, but we haven't seen an audit. And we're 2 years into this receivership. And I had been involved in other receiverships in real estate matters where the receiver would send out basically a monthly P&L of, what was going on and how things had changed, et cetera. And here we are 2 years in to an audit with a forensic accountant attached to it, and we still haven't seen an accounting. So I said, provide an accounting. He didn't disagree, but he said he'd have to ask his client. Again, we're 4 days after this discussion, haven't heard anything back about any type of accounting coming in. And again, I don't know if there's anything that's squirrely in the accounting. My only guess would be maybe expenses. The expenses of the receivership might be questioned. Maybe, I don't know. I'm just speculating here, complete speculation. But I'd wonder why somebody wouldn't throw out an accounting of how the monies were expended, unless they were concerned about some of the items. Maybe they were just like, that's their style. But if that's just not their style and they're concerned about some of the items, I'd like to see what the items are and also like to see what the accounting is. The Receivers Council didn't see any problem with it, but as of today, I have not seen anything further. And I would think, by the way, that especially having a forensic accountant on board, that if you want to do an accounting, that should take you like 5 minutes, an accounting of the estate, the receivership so far. And it bothers me that we haven't seen it. I also threw in, and I think I got a chuckle out of the Receivers Council about what this forensic accountant who's been with the receiver has been doing, and how has he helped get this audit done, and what has he been paid, and why are we having these problems? Isn't that the idea of having an expert involved? He kind of chuckled at what I said, didn't comment beyond that. I interpreted as he didn't disagree with my questions, asking for the value of someone who and again, not the fault of that person, but nobody's told us what they have done, what the benefit is, what the cost was, what they were hired to do. And that firm or person has been around, I believe, since the start of the receivership. So the fact that the Receivers Council didn't object kind of made me feel a particular way about whether he supported my position or not. 4, the audit. I expressed my dissatisfaction about how the receiver had been handling the audit, yada, yada, yada. I attacked in part how the Receivers Council and it was a different council than I was speaking to on the phone, but how the Receivers Council had characterized my argument about Barton, and it's happened 2 or 3 times now, where they're trying to belittle it, whatever. I don't take it personally, other than it's an attempt to negate the argument. But I've raised the issue with Barton multiple times and in court about the fact that it shouldn't have taken Barton so long to do nothing before they quit. And in part, the first person who was involved got pregnant and she wasn't able to complete her job and it wasn't relied upon, whatever. Their response always is, how are we supposed to know she was pregnant, et cetera. We shouldn't be attacking a pregnant woman. That's basically the response. And my response here, just on that one topic, is, that's all well and good, whatever. But if you look back at your report, you reported right after Barton was hired that within 30 days, the audits would be done. So this is after Barton was hired. And so whether our auditor partner 9 months later had to step out because she wasn't able to complete it because she was pregnant has nothing to do with the representation after Barton was hired that it was going to be done in 30 days. And again, no response to that, because what are you going to say? You can't respond because their argument about the pregnancy, in my opinion, makes no sense and is BS. Again, I raised the issue about the forensic accountant, and he laughed, because what are you going to say? How are you going to justify the benefit? How are you going to justify the benefit of what the forensic accountant has brought to the table if you don't know what the forensic accountant has brought to the table, because it hasn't been disclosed? And beyond that, if you were just going to guess based upon how well the audit has been proceeding, you can then guess how fine a job a forensic accountant who is supposed to be, I guess, involved in assisting the receiver in completing accounting functions, etc., and forensic accounting functions, I guess, because that's the name of the person. So you wonder why somebody in that position wouldn't have about all the deficiencies in the audit process in the last 2 years. It makes you wonder, makes you question the amount, etc. There was no real response again from the Receivers Council other than the chuckle. So the first 4 issues, the loan investment, no, I haven't seen any kind of justification, response, whatever. The audit, same. The marshaling of the audits, I was told there'd be a communication with the receiver, but I haven't seen any accounting. The cash settlement disclosure about any insider discussions, haven't seen anything about that. The 2 that I'd be most concerned about would be the loan investment and the audit, and the other 2 are secondary. So that's those 4. The last one was the status of the outside deals that were pending. And since kind of now we'll go back to that hearing, one of those was the Trento deal. And obviously they withdrew, at least for now, they withdrew their application to intervene in the court. That doesn't mean they withdrew their proposal. That just means they withdrew their legal document to intervene in the lawsuit. Those are two different things. I wasn't involved in drafting the paperwork or whatever, or filing that stuff, or the withdrawal, etc. So I don't know what their what the specific thought process was for that, but that was one of the pending transactions. So what was disclosed? What was disclosed in the report were the 3 transactions: AI-versity, Trento, and a unnamed Korean deal. So I bitched at the Receivers Council for having disclosed those 2 non-public transactions, and again, there was no real response, rebuttal, and I haven't received any response. That they also, every time I asked them, and this happened many times, I would ask them for a piece of information. Their response would be, it's non-public information, the stock's still trading, so we can't tell you. And here, nothing's changed, and they're putting out non-public information that if somebody's able to trade, they can trade on it. So I just thought that was something about that I found inappropriate, let's say. I also, my conclusion was, and I think I said this before, I thought the last report was written by somebody who had not written the prior reports. And in my discussion with the Receivers Council, I concluded that I was correct, because they intimated that was the case, that they were much less involved in the actual preparation of that particular report than other reports. So it was kind of funny. So I kind of looked at that report, and it did look less polished, let's say, than prior reports. And it raised, obviously, these issues, especially the conflict issue. I mean, so kind of way I look at it, it raises the issue of conflict of interest, non-disclosure, raises issues. That's what I'm saying, is that this doesn't mean that they're definitive, but it raises concerns about conflicts of interest, insider-related actions, issues related to improper SEC filings, especially where GTII is trying to get relisted, uplisted, north listed, some listed. The fact that there may be inconsistent SEC filings, if I'm correct, then that probably is not a good thing. The cash settlement is the cash settlement. They could still disclose it. The marshaling of assets, they could come up with an accounting. The audit is the audit. It hasn't been done. No engagement letter still, as of today, still no engagement agreement, no kind of indication when there will be an engagement agreement. I can't say. So with that, I'm using that as information to operate on also. But going back to the issue of the potential transactions, So we've had like the removal of at least the Trento application. We don't know where the Korean deal stands. Hopefully it's in South, not North Korea. And again, I expressed my dissatisfaction with them kind of going back on their policy of not disclosing non-public information. So what does that mean? So I looked at all that and I decided I would go forward and make a motion to either terminate. So this is like burying the lead. Kind of wait to the very end. So I determined after having the interaction, one, after kind of looking through this stuff, two, after having interaction with the Receivers Council, the response, non-response, I am going to move forward with some kind of motion with regard to the receiver. I have still work to do with regard to research. I'm not a Nevada lawyer, so it'll take me a little longer to get this done. As I indicated, this particular judge has already indicated that he would award at least legal fees for inappropriately filed documents. I don't think Judge Williams, the prior judge, did. So I want to make sure, even though I'm not a Nevada lawyer, I want to make sure I comply with everything and everything is kosher and in effect. But I will. I'm decided I'd go forward, try to terminate or restrict the powers of the receiver, and we'll see what happens. I know that some of you are favor that, some of you don't. I have to make sure there is an alternative receiver to go, or somebody who can stand in the shoes if the receiver is removed. So that might also be at least a slow impediment, but nothing to hide. I kind of indicated my intentions, so now it's public that I will be moving to, restrict or terminate the receivership. I will keep you all apprised as I file it, as soon as it's filed. We'll go from there. We'll see what the judge's reaction is to it. I would say, but for the issue about the loan and investment being just kind of slow, and again, this is just opinion, being just slow and not accomplishing things as fast as I would like, it's probably not sufficient to get rid of the receiver. I think the issue about that one transaction that really is suspect, in my opinion, that creates a different issue. So now we don't just have an issue of, maybe you didn't do the fastest job, but you tried your hardest. But here we have a transaction just kind of looks suspicious. It's treated suspiciously. It wasn't presented before the court, so we'll see. I'm not trying to be. This is like the ultimate transparency. I've not kind of told you also, Mr. Receiver, what the issue is. So I'm waiting to hear an interesting explanation. I expect an interesting explanation about that. I was talking to somebody about that, and I was saying, it's like literally on one page you say black, and the next page you say white, and then some lawyer will make an argument how those are the same. So I expect somebody to try to rationalize these obvious inconsistencies, but in my mind, it creates an issue. And again, it may be completely innocuous, but it creates at least it's a mistake. And that mistake, when put in context with the lack of performance on issues that are key for shareholders, 2 years, I think we're enough. So that's where we are. Again, I'll keep you apprised of my progress in putting together the paperwork. And if I hear anything else from anybody, or I hear back from the receiver, or I hear about, whatever, I will let you know. And most of all, I will keep you apprised of my progress in completing the paperwork to file with the court, and we'll see what happens. So to everybody out there, have a great weekend, and we'll see what goes on. But now at least we will try and take a little more affirmative action with this new judge.